Leaves, Labor Code. Service incentive leave under the implementing rules and regulations, exemptions from coverage of holiday and service incentive leave pay refer to field personnel and other employees whose time and performance is unsupervised by the employer, including those who are engaged on task or contract basis. Special laws, parental leave for solo parents. Congress has also enacted legislation in support of this tradition. Support of this tradition, the Labor Code, for example, does not distinguish between married and unmarried female employees for purposes of availing of maternity leave privileges. Maternity leave benefits are extended to a pregnant female employee irrespective of marital status under our Public Act number 8972. Solo parents entitled to government support include women who give birth to and rear a child as a result of rape and other crimes of chastity, and unmarried women who prefer to keep and rear their children instead of having others care for them or giving them up to a welfare institution. Under Section 13 of Republic Act number 9710, women faculty and students cannot be expelled or refused readmission solely on account of having contracted pregnancies outside of marriage during their term in school. Special laws. Expanded maternity leave refers to leave of absence granted to married women employees in case of pregnancy or by reason of confinement, abortion, or miscarriage, in addition to the vacation sick leave to which they may be entitled. Special laws. Maternity leave. The Expanded Maternity Leave Act allows any female worker who will avail of maternity leave to transfer up to 7 of her 105 days of paid leave to the child's father, whether they are married or not. Notwithstanding any law, rules, and regulations to the contrary, every married male employee in the private and public sectors shall be entitled to a paternity leave of 7 days with full pay for the first 4 deliveries of the legitimate spouse with whom he is cohabiting. The male employee applying for paternity leave shall notify his employer of the pregnancy of his legitimate spouse and the expected date of such delivery. Special laws. Gynecological leave. Gynecological disorders refers to disorders that would require surgical procedures such as but not limited to dilation and curettage, and those involving female reproductive organs such as vagina, cervix, uterus, fallopian tubes, ovaries, breasts, adnexia, and pelvic floor as certified by a competent physician. The special leave benefit shall be granted to a qualified female. Time check 10 o'clock 10 a.m. May 26, 2022. The special leave benefit shall be granted to a qualified female employee after she has undergone surgery without prejudice to an employer, allowing an employee to receive her pay before or during the surgery. It may be used for a period covering the surgery until recuperation. Absence incurred from the pre-surgery period, as well as those in excess of the 2 months allowed under the special leave benefit, may be charged against the employee's earned leave credits. To apply for special leave, a woman employee shall file her application leave within a reasonable period of time from the expected date of surgery or within such period as may be provided by company rules or by a collective bargaining agreement. Special laws. Battered woman leave. In the recent case of Garcia versus Gilon, this court rejected the argument that Republic Act number 9262 or the Anti-Violence Against Women and Children violated the Equal Protection Guarantee. According to this court, the unequal power relationship between women and men. The fact that women are more likely than men to be victims of violence and the widespread gender bias and prejudice against women justify the enactment of a law that specifically punishes violence against women, especially groups of employees. Sexual harassment in the work environment. Definition: sexual harassment in an education or training environment is committed when sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Sexual harassment is a valid cause for separation from service in Villarama versus National Labor Relations Commission, wherein a managerial employee committed sexual harassment against his subordinate. The court held that sexual harassment is a valid cause for separation from service. As a managerial employee, petitioner is bound by a more exacting work ethic. Duties and liabilities of employers shall be the duty of the employer or the head of their work-related educational or training environment or institution to prevent or deter the commission of acts of sexual harassment and to provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. The employer or head of office, educational, or training institution shall be solidarily liable for damages arising from the acts of sexual harassment or committed in the employment, education, or training environment if the employer or head of office, education, or training institution is informed of such acts by the offended party and no immediate action is taken. Applicable laws. Sexual Harassment Act. Sexual harassment in an education training environment is committed when sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Contrary to Rayala's claim, it is not essential that the demand, request, or requirement be made as condition for continued employment or for promotion to a higher position. It is enough that the respondent's acts result in creating an intimidating, hostile, or offensive environment for the employee. That the acts of Rayala generated an intimidating and hostile environment for Domingo is clearly shown by the common factual finding of the investigating committee, the OP, and the CA that Domingo reported the matter to an office mate and after the last incident filed for a leave of absence and requested transfer to another unit. Applicable laws. Safe Spaces Act. It is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. It is likewise the policy of the state to recognize the role of women in nation building and ensure the fundamental equality before the law of women and men. The state also recognizes that both men and women must have equality, security, and safety, not only in private but also on the streets, public spaces, online, workplaces, and educational and training institutions. Catcalling refers to unwanted remarks directed towards a person, commonly done in the form of wolf whistling and misogynistic, transphobic, homophobic, and sexist slurs. Employee refers to a person who, in exchange for remuneration, agrees to perform specified services for another person, whether natural or juridical, and whether private or public, who exercises fundamental control over the work, regardless of the term or duration of agreement, provided that for the purposes of this law, a person who is detailed to an entity under a subcontracting or secondment agreement shall be considered an employee. Employer refers to a person who exercises control over an employee, provided that for the purpose of this act, the status or conditions of the latter's employment or engagement shall be disregarded. Gender refers to a set of socially ascribed characteristics, norms, roles, attitudes, values, and expectations identifying the social behavior of men and women and the relations between them. Gender-based sexual Online sexual harassment refers to an online contact targeted at a particular person that causes or likely to cause other mental, emotional, or psychological distress and fear of personal safety. Sexual harassment acts including unwanted sexual remarks and comments, threats, uploading or sharing of one's photos without consent, video and audio recordings, cyberstalking and online identity theft. Gender and identity and or expression refers to the personal sense of identity as characterized, among others, by manner of clothing, inclination, and behavior in relation to masculine or feminine conventions. A person may have a male or female identity with physiological characteristics of the opposite sex, in which case this person is considered transgender. Public spaces refer to streets and alleys, public parks, schools, buildings, malls, bars, restaurants, transportation terminals, public market spaces, uses evacuation centers, government offices, public utility vehicles as well as private vehicles covered by app-based transport network services and other recreational spaces and such as, but not limited to, cinema halls, theaters and spas. And stalking refers to conduct directed to a person involving repeated visual physical proximity. Non-sexual, non-consensual communication or a combination thereof that cause or will likely cause a person to fear for one's own safety or the safety of others or to suffer emotional distress. Working conditions for special groups of employees. Apprentices and learners. We agree with the Office of the Solicitor General's association that teachers, heads of business establishments, and heads of NGOs can validly confirm the medical condition of their students, employees with apparent disability for obvious reasons, as compared to non-apparent disability which can only be determined by licensed physicians. Under the Labor Code, disabled persons are eligible as apprentices or learners provided that their handicap are not as much as to effectively impede the performance of their job. We find that heads of business establishments can validly issue certificates of disability of their employees because, aside from the fact that they can obviously validate the disability, they also can have medical records of the employees as a prerequisite in the hiring of employees. Hence, Part 4E NCDA AO number 1 is logically valid. Disabled workers were likewise not persuaded by the argument of petitioners that the definition of disabilities under the subject laws is vague and ambiguous because it is allegedly so general and broad that the person tasked with implementing the law will undoubtedly arrive at different interpretations and applications of the law. Aside from the definitions of a person with disability or disabled persons under Section 4 of Republic Act number 7277 as amended by RA number 9442 and in the IRR of Republic Act number 9442, NCDAAO number 1 also provides identification cards shall be issued to any bona fide PWD with permanent disabilities due to any one or more of the following conditions: physiological, chronic illness, learning, mental, visual, orthopedic, speech and hearing conditions. This includes persons who is suffering from disabling diseases resulting to the person's limitations to do day-to-day activities as normally as possible, such but not limited to those undergoing dialysis, heart disorders, severe cancer cases, and such other similar cases resulting to temporary or permanent disability. Similarly, the OHAO number 2009-0011 defines the different categories of disability as follows. Rule 4, Section 4, Paragraph B of the implementing rules and regulations of this Act required the Department of Health to address the health concerns of 7 different categories of disability, which include the following: psychological and behavioral disabilities, chronic illness with disabilities, learning, cognitive or intellectual disabilities, mental disabilities, orthopedic, moving, and communication defects. Elemental is the rule that when laws or rules are clear, when the law is unambiguous and unequivocal application and interpretation thereof is imperative. However, where the language of a statute is vague and unambiguous, an interpretation thereof is resorted to. A law is deemed ambiguous when it is capable of being understood and by reasonably well-informed persons in either of 2 or more senses. The fact that a law admits of different interpretations is best evidence that it is vague and ambiguous. Disabled workers, discrimination on employment. No entity, whether private or public, shall discriminate against an unqualified disabled person by person of disability with regard to job application procedures, the hiring, promotion, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. Gender discrimination. Equal protection simply requires that all persons or things similarly situated should be treated alike both as to rights conferred and responsibilities imposed. The oft-repeated disquisition in the early case of Victoriano versus Elizalde Rupe Workers Union is instructive. The guarantee of equal protection of the laws is not a guarantee of equality in the application of the laws upon all citizens of the state. It is not therefore a requirement in order to avoid the constitutional prohibition against inequality that every man, woman, and child should be affected alike by a statute. Equality of operation of statutes does not mean indiscriminate operation on persons merely as such, but on persons according to the circumstances surrounding them. It guarantees equality, not identity of rights. The Constitution does not require that things which are different in fact be treated in law as though they were the same. The Equal Protection Clause does not forbid discrimination as to things that are different. It does not prohibit legislation which is limited either in the object to which it is directed or by the territory within which it is to operate. The Equal Protection of the Laws clause of the Constitution allows classification. Classification in law, as in the other departments of knowledge or practice, is the grouping of things in speculation or practice because they agree with one another in certain particulars. A law is not invalid because of simple inequality. The very idea of classification is that of inequality, so that it goes without saying that the mere fact of inequality in no manner determines the matter of constitutionality. All that is required of a valid classification is that it be reasonable, which means that the classification should be based on substantial distinctions which make for real differences, that it must be germane to the purpose of the law, that it must not be limited to existing conditions only, and that it must apply equally to each member of the class. This court has held that the standard is satisfied if the classification or distinction is based on a reasonable foundation or rational basis. Stipulation against marriage. Statutory law is replete with legislation protecting labor and promoting equal protection in employment. No less than the 1987 Constitution mandates that the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. The Labor Code of the Philippines, meanwhile, provides Article 136 stipulation against marriage. It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman employee shall not get married, or to stipulate expressly or tacitly that upon getting married a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of her marriage. Prohibited acts. According to the Philippine Commission on Women, the national machinery for gender equality and women's empowerment, violence against women is deemed to be closely linked with the unequal power relationship between women and men, like otherwise known as gender-based violence. Societal norms and traditional dictate people to think men are the leaders, pursuers, providers, and take on dominant roles in society, while women are nurturers, men's companions and supporters, and take non-subordinate roles in society. This perception leads to men gaining more power over women. With power comes the need to control, to retain the power. And violence against women is a form of men's expression of controlling women to retain that power. In the recent case of Garcia versus Drilon, this court rejected the argument that Republic Act No. 9262, or the Anti-Violence Against Women and Their Children, violated the equal protection guarantee. According to this court, the unequal power relationship between women and men, the fact that women are more likely than men to be victims of violence, and the widespread gender bias and prejudice against women justify the enactment of a law that specifically punishes violence against women, special groups of employees, minors. Minimum employable age is number 1. No child below 15 years of age shall be employed except when he works directly under the sole responsibility of his parents or guardian, and his employment does not in any way interfere with his schooling. B. Any person between 15 and 18 years of age may be employed for such number of hours, such period of the day as determined by the Secretary of Labor and Employment in appropriate regulations. The foregoing provisions shall in no case allow the employment of a person below 18 years of age in an undertaking which is hazardous or deleterious in nature, as determined by the Secretary of Labor and Employment. Prohibition against child discrimination. The employer shall discriminate against any person in respect to terms and conditions of employment on account of his age. Kasambahays, among the employer's management prerogatives is the right to prescribe reasonable rules and regulations necessary or proper for the conduct of business, to provide certain disciplinary measures, implement said rules, and to assure that the same would be complied with. At the same time, the employee has the moral duty to obey rules, orders, and instructions of the employer, and willful of intentional disobedience thereto. So, general rule justifies termination of the contract of service and the dismissal of the employee or workers. Regulation of industrial home workers. The employment of industrial home workers and field personnel should be regulated with government through the appropriate regulations issued by the Secretary of Labor and Employment to ensure the general welfare and protection of home workers and field personnel and the industries employing them. Regulations of Secretary of Labor. The regulations of orders to be issued pursuant to this chapter shall be designed to assure the minimum terms and conditions of employment to the industrial home workers or field personnel. This distribution of homework for purposes of this chapter, the employee of this includes any persons, natural or artificial. Made available for worker performing light work to the arrangements. Night workers. Night worker means any employed person whose work requires performance of a substantial number of hours of night work, which exceeds a specified limit. This limit shall be fixed by Secretary of Labor after consulting the workers' representatives or labor organizations and employers. Suitable first aid facilities should be made available for workers performing night work, including arrangements for such workers where necessary can be taken immediately to a place for medical treatment. Matters of establishment and transportation of outdoor premises to the nearest point of the residence, subject to exceptions and guidelines to be provided by the law. Before introducing work schedules regarding the services of night workers, the employer shall consult the workers' representatives, labor organizations, or concerned on the details of such night schedules and the forms of organization of night work shelter are best adapted to the establishment and its personnel, as well as on the occupational health measures, social services which are required. Establishments employing night workers consultation should take place regularly. Migrant workers, in case of termination for which is employment not just, valid, or authorized costs as defined by law or contract, or any unauthorized deductions from the migrant worker's salary, the worker should be entitled to the full reimbursement of his placement fee and the deductions immediate interest 12% per annum, plus his salaries for the unexpired portion of his employment contract or for 3 months for every year of the unexpired term. Service as security guards. The security service contractor is the employer of its security guard and similar personnel. The principal where the security guards are assigned is considered an indirect employer for unpaid temporary wages, other wage-related benefits based on the joint and several liability of the principal and service contractor under the legal law, unless the private security agency is owned, managed, or controlled by the principal, or the facts show that the principal controls the manner by which the security service is performed, or where the security guard is directly hired by the establishment. Also, employer-employee relationship. The rule is the arbitrator's decision which granted separation pay in lieu of reinstatement is appealed by any party. The employer-employee relationship subsists, and until such time the decision becomes final and executory, the employee is entitled to all the monetary awards awarded by the LA. The established criteria for the determination pages of an employer-employee relationship are: first, the selection and engagement of the employee; second, the payment of wages; third, the power of dismissal; and fourth, the power to control the employee's conduct. Tests to determine existence etched in an infinite stream of cases are four standards in determining the existence of an employer-employee relationship, namely: manner of selection and engagement of the putative employee, the mode of payment, wages, the presence or absence of power of dismissal, and the presence or absence of control of the putative employee's conduct. To ascertain the existence of an employer-employee relationship, jurisprudence has invariably adhered to the fourfold test, to wit: the selection and engagement of the employee, the payment of wages, the power of dismissal, and the power to control the employee's conduct, or the so-called control test. To determine the existence of said relation, case law has consistently applied the fourfold test to selection and engagement. Of the employee, the payment of wages, or dismissal, the employer's power to control the employee, and the means and methods by which the work is accomplished. So, kaya ako nanguuyam because I just woke up. I yawned because I just woke up. I had a break, really long break, 4 hours break. For this criteria, the so-called control test is generally regarded as the most crucial and determinative indicator of the presence or absence of an employer-employee relationship. Legitimate subcontracting is distinguished from labor-only contracting. Labor-only contracting refers to an arrangement where the contractor or subcontractor merely recruits, supplies or replaces workers to perform a job or work for a principal, and the elements enumerated in section 5 hereunder. The present contracting or subcontracting refers to an arrangement whereby a principal agrees to farm out to a contractor the performance or completion of a specific job. Or work within a definite or predetermined period regardless of whether such job or work is to be performed or completed within or outside the premises of the principal elements. Absolute prohibition against labor-only contracting. Labor-only contracting, which is totally prohibited, refers to an arrangement where the contractor or subcontractor does not have substantial capital. Contractor or subcontractor does not have investments in the form of tools, equipment, machinery, supervision, work premises, or others, and contractors or subcontractors, employees recruited and placed or performing activities which are directly related to the main business operation of the principal. Or the contractor or subcontractor does not exercise the right to control over the performance of the work of the employee. Trilateral relationship, tripartism, and tripartite conferences. Tripartism in labor relations is hereby declared a state policy. Towards this end, labor workers and employers shall, as far as practicable, be represented in decision and policy-making bodies of the government. The Secretary of Labor and Employment or his duly authorized representatives may from time to time call a national, regional, or industrial tripartite conference of representatives of government workers and employers, where the consideration and adoption of voluntary rules or principles designed on industrial is based on social justice to align labor movement relations with established priorities in economic and social development. In calling such conference, the Secretary of Labor and Employment may consult with accredited representatives of workers and employers. Kinds of employment. Article 280 of the Labor Code and Jurisprudence identify three types of employees, namely regular employees, or those who have regular employees, or those who have project employees as well. Regular, casual, contractual, project. Seasonal. Fixed term. Regular employees are those who have been engaged to perform activities necessary or desirable in the usual business or trade of the employer. Project employees were those whose employment is being fixed for a specific project or undertaking, the completion or termination of which has been determined at employees are those who are neither regular nor project employees. Article 295 Labor Code contemplates four kinds of employee: regular, casual, contractual, project, seasonal project. Regular, for an academic personnel to acquire a regular and permanent employment status, it is required that he is considered a full-time employee. He has completed the required probationary period and C. His service must have been satisfactory. However, it must be emphasized that mere completion of the probationary period does not ipso facto make the employee a permanent employee of the educational institution, as he would only qualify as such upon fulfilling the reasonable standards for permanent employment as faculty member. This is especially true in the case of institutions of higher education which, consistent with academic freedom and constitutional autonomy, has the prerogative to provide standards for its academic personnel and to determine whether the same is faculty met. Thus, at the end of the probationary period, the decision to rehire a probationary employee and thus place the platform a regular permanent status belongs to the educational institutions as the employer alone. Otherwise stated, upon the expiration of their contract, academic personnel and probationary probation cannot automatically claim security of tenure and compel their employers to renew their employment contracts, which would tend to transform them to regular and permanent employees. The employee has been performing the job for at least 1 year, even if the performance is not continuous or merely intermittent. The law deems the repeated or continued performance as sufficient evidence of the necessity, if not indispensability, of the activity in the business. Casual. Unemployment shall be deemed to be casual. It is not covered by the preceding paragraph, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. Contractual, since working depends on the availability of such contracts, necessarily the duration of the employment of its workforce is not permanent but autonomous with the projects to which they are assigned and from whose payrolls they are paid. Project. Under Article 280, project employment is one which has been fixed for a specific project for or undertaking. Completion or termination of which has been determined at the time of the engagement of the employee. Provisions of written agreement to the contrary, notwithstanding and regardless of the oral argument. Regular project employee. Seasonal temporarily laid off during off-season are not separated from service in some period but are merely considered on leave until re-employed. The nature of their relationship is such that during off-season they are temporarily laid off during summer season they are re-employed or when their services may be needed. They are not strictly speaking separated from service but are merely considered as on leave of absence without pay until they are re-employed. Fixed term. Project employment should not be confused and interchanged with fixed term employment. Fixed term employment. The undecisive determinant of fixed term employment is not the activity that the employee is called upon to perform, but the day certain agreed upon by the parties for the commencement and termination of the employment relationship. Probationary private school teachers. Under the aforecited rule, the following conditions must occur in order that a probationary teacher may be extended a regular appointment. The faculty member will satisfactorily complete the probationary period of 4 semesters or 2 years, within which his performances shall be observed and evaluated for the purpose of determining his competence and fitness to be extended permanent status, and the faculty member must pass the PMET or an equivalent civil service examination. This is by no means to assert that probationary teachers do not enjoy security of tenure. They enjoy security of tenure in the sense that during their probationary employment, they cannot be dismissed except for cause. However, upon expiration of their contract of employment, probationary academic personnel cannot claim security of tenure and compel their employers to renew their employment contracts. In fact, the services of an employee hired on a probationary basis may be terminated when he fails to qualify as a regular employee in accordance with reasonable standards known by the employer to the employee at the time of his engagement. Termination by employer. In termination cases, the burden of proof rests on the employer to show that the dismissal is for a just cause. The employer must inform the employee of the cause or causes for his or her termination and thereafter the employer's decision to dismiss him. Aside from the notice requirement, the employee must be accorded the opportunity to be heard. The penalty of dismissal from service includes cancellation of eligibility for forfeiture of leave credits and retirement benefits, and disqualification from reemployment in the government service. The penalty of dismissal carries with it the accessory penalties of cancellation of eligibility, forfeiture of retirement benefits. Requisites for validity. Termination by employer. An employer may terminate an employment for any of the following causes: serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work; loss and habitual neglect by the employee of his duties; fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. Because it's for validity. Termination by employer. An employer may terminate an employment for the lawful orders of his employer. Loss and habitual neglect by the employee of his duties. Employer or duly authorized representative. Offense by the employee against the person of his employer or any which it is duly authorized representatives. Analogous to the foregoing, substantive due process, just process. An employee's guilt or innocence in a criminal case is not determinative. So for just or authorized cause for his or her this will settle that conviction in a criminal case is not necessary to find just cause. Employment, as in this case, criminal and criminal cases involving an employee arising from the same infraction are separate and distinct proceedings which will not arrest any judgment from one to the other. Substantive due process authorized causes. A project employee is assigned to a project which begins and ends at determined or determinable times, unlike regular employees who may only be dismissed for just and authorized causes undeterminable. As a services of employees who are hired as project-based employees may be unlawfully terminated at the completion of the project. Procedural due process. The most basic tenet of due process is the right to be heard. Denial of due process means the total lack of opportunity to be heard or to have one's day invoked. Preventive suspension. Preventive suspension may be legally imposed against an employee whose alleged violation is the subject of an investigation. The purpose of suspension is to prevent harm or injury to the company as well as to fellow employees. Preventive suspension is justified where the employee's continued employment poses a serious and imminent threat to the life or property of the employer or of the employee's co-workers. Illegal dismissal. An employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges and to his full back wages, inclusive of allowances and to his or other benefits, with their monetary equivalent computed from the time of compensation was withheld from him to the time of actual reinstatement. In illegal dismissal cases, the fundamental rule is that when an employer interposes the defense of resignation, the burden to prove that the employee indeed voluntarily resigned necessarily rests upon the employer. Reliefs from illegal dismissal. An illegally dismissed employee is entitled to two separate reliefs: full back wages and reinstatement. The normal consequences of respondents' illegal dismissal then are reinstatement without loss of seniority rights and payment of back wages imputed from time was withheld up to the date of actual reinstatement, where reinstatement is no longer viable as an option. Separate pay equivalent to 1 month's salary for every service should be awarded as an alternative. Where reinstatement is no longer viable as an option, separation pay equivalent to 1 month's salary for every year should be awarded as an alternative. The payment of separation pay is in addition to payment of back wages given the strained relations between the parties. The award of separation pay in lieu of reinstatement is in order. An illegally dismissed employee should be entitled to either reinstatement if viable or separation pay if reinstatement is no longer previsible plus back wages in either instance. Reinstatement as labor law concept means the admission of an employee back to work prevailing prior to his dismissal. Restoration to a state or position from which one had been removed or separated, which presupposes that you shall be no deduction of bracket or deduction of salary benefits and other privileges if the position previously occupied position and other privileges. Money claims arising from employer-employee relationship. Generally, the employee's waiver or quit claim cannot prevent the employee from demanding benefits to which she is entitled from filing an illegal dismissal case. The all quit claims are invalid and against public policy if the agreement was voluntarily entered into and represents a reasonable settlement. It is binding on the parties and may not be later resolved simply because of a change of mind. When not deemed dismissed, the employee in floating status, a bona fide suspension of the operation of a business or undertaking for a period not exceeding 6 months or the fulfillment by the employee of a military or civic duty shall not terminate employment. In all such cases, the employer shall reinstate the employee to his former position without loss of seniority of rights if he indicates his rights or desire to resume his work not later than 1 month of the resumption of operations of his employer or from his relief from the military or civic duty. Termination by employment. Employee may terminate without just cause the employer-employee relationship by serving a written notice on the employer at least 1 month in advance. Employer upon such notice will serve may hold the employee liable for damages. An employer may put an end to the relationship without serving any notice on the employer for any of the following just causes. First, that the serious insult by the employer or his representative on his owner and person of the employee, inhuman and unbearable treatment accorded the employee by the employer or his representative, commission of a crime or offense by the employer or his representative against the person of his employee or any of the immediate members of his family, and other causes analogous to any of the foregoing. Resignation is the voluntary act of employees who are compelled by personal reasons to dissociate themselves from their employment. It must be done with the intention of relinquishing an office, accompanied by the act of abandonment. All resignation letters containing words of gratitude may indicate that the employees were not forced into a resignation. This fact alone is not conclusive proof that they intelligently, freely, and voluntarily resigned to whom the resignation letters couched in terms of gratitude are by themselves conclusive proof that the employees intended to relinquish their posts would open the floodgates to possible abuse. In order to withstand the test of validity, resignations must be made voluntarily and with the intention of relinquishing the office, or with an act of relinquishment. Therefore, in order to determine whether the employee is truly intended to resign from their respective posts, we cannot merely rely on the tenor of the resignation letters, but must take into consideration the totality of circumstances in each particular case. Distinguish voluntary resignation from constructive dismissal, where the resignation of an employee to be a viable defense in an action for legal dismissal. An employer must prove that the resignation was voluntary and its evidence thereof must be clear, positive, and convincing. To determine whether the employee indeed intended to relinquish such employment, the act of the employee before and after the alleged resignation must be considered. Since double claims to have been forced to commit resignation letter, it is incumbent upon him to prove with clear and convincing evidence that his resignation was not voluntary but was actually a case of constructive dismissal, example, a product of coercion or intimidation. The transfer could not be validly assigned as a form of constructive dismissal or as having been good as a form management has a prerogative to determine the place where the employee is best qualified to serve the interest of the business given the qualifications, training, and performance of the affected employee. There is a constructive dismissal when an employer's act of clear discrimination and sensibility or disdain becomes so unbearable on the part of the employee so as to foreclose any choice on his part except to resign from such employment. Retirement is a result of bilateral act of the parties, a voluntary agreement between the employer and the employee, whereby the latter, after reaching a certain age, agrees to sever his or her employment within the former. Jurisprudence is replete with cases discussing the employer's prerogative to lower the compulsory retirement age subject to the consent of its employment. In the absence of any applicable agreement, an employee must first retire when he is at least 60 years of age, and 2. Serve at least 5 years in the company to entitle him or her to a retirement benefit of at least 1/2 month's salary for every year of service, with a fraction of at least 6 months being considered as 1 whole year. Labor relations. Labor relations. Right to self-organization. The right to self-organization is not limited to unionism. Workers may also form or join an association for mutual aid and protection for other legitimate purposes. Who may or may not exercise the right. Right to self-organization includes right to form a union, workers' association, and labor management councils. More often than not, the right to self-organization connotes unionism. Workers, however, can also form and join a workers' association, as well as labor management councils. Expressed in the highest law of the land is the right of all workers to self-organization. Section 3, Article 13 of the 1987 Constitution states that Section 3, the state shall afford full protection to labor, local and overseas organized and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful and certain activities, including the right to strike in accordance with law. And Section 8, Article 3 of the 1987 Constitution also states that Section 8, the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law, shall not be abridged. In relation thereto, Article 3 of the Labor Code provides that Article 3, Declaration of Basic Policy, the state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. The state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. Substitutionary doctrine. The substitutionary doctrine provides that the employees will not revoke the validity executed collective bargaining contract with their employer by the simple expedient of changing their bargaining agent. The new agent must respect the contract. Employers should their new bargaining agent cannot relinquish on the collective bargaining contract. Substitutionary doctrine cannot be invoked to support the claim that a newly certified collective bargaining agent automatically assumes all personal undertakings, such as the no-strike stipulation, in this case assumed by the deposed union when the BPWU bound itself and its officers not to strike. It could not bind all the rival unions because the BPWU was the agent only of their employees, not of the other forms, other unions which possess distinct personalities. The substitutional doctrine only provides that the substitutional doctrine only provides that employees can revoke the validity of executed collective bargaining contract with their employer by the simple expedient of changing the bargaining agent, and it is in the light of this that the phrase said new agent would have to respect said contract must be understood. Only means that the employees through their new bargaining agent had renege on their collective negotiation. Which is the arrangement is not premised upon the majority of the employees as an entity under the statute is true party in interest or labor when withholding its rights through the mere agency of their union representative. Thus, any exclusive interest claim agent is indefeasible of the will of the principal. We'll stop there. Next topic is bargaining.